running around with a reggae that has no sober drivers, and therefore, in my view, those two stand out as very crucial and critical elements of the judgment. The judges went on, and I think they pronounced themselves in more than, 18 issues. I think the only issue they left hanging, and I can tell you that will come out later. The fact that the president and Raila Odinga used public resources without a legal framework that helps them to draw money from the public coffer. They said that they would rather leave that issue to the Auditor General for now. Once the Auditor General audits those figures, because they said it was a popular initiative, then therefore it will be audited, and possibly there will be another litigation to make them for sure pay for using Kenyan funds illegally. The other issue that, and I will finish with this one so that I can give my colleagues leave the other issues, is that the president was found, is actually indicted by the court. He was found to have breached the integrity and leadership provisions and text of the Constitution of Kenya, Chapter 6, and therefore it is possible to impeach the president now with this pronouncement. I believe our teams are not interested in impeaching the president, but what does this mean for Kenyans? That the president should be number one in defense and promotion and protection of the Constitution. He surely has failed. You can imagine, since last 2 years, the judges, 41 judges, have been waiting. There are many instances we can cite against our president having violated the Constitution. 41 judges have been processed by the Judicial Service Commission, and to date, he has failed to actually appoint them. And constitutionally, he is the one mandated to do that. We never left a gap for any other organ, because that is the tail end. He has failed to do an honorary duty, appointing 41 judges. So I want to rest there and say, hongera Mama Teresa, hongera our judiciary, hongera the judges, and the judges should walk tall. Nobody should think that they will intimidate the judges. We created an independent judiciary through this constitution, and therefore we would expect that nobody should start demonstrations against it. The demonstrations we should actually carry out now is to celebrate the judges, is to herald them, is to commend them for their good work. Whether there is any other course of action thereafter, we, those who believe in the Constitution, and I voted no on the floor of the House, and I say that I am voting no to defend the Constitution.
Thank you very much. I'll also highlight a few things, then switch off, of course, to the native language for my commoners to understand it. Today is a very happy day. I mean, every person is very happy because some of us have been vindicated. We've been all over telling the masses the truth, that the process of changing the constitution of this country that was initiated by the president and the Right Honorable Raila Odinga was a sham, was flawed. But we're very happy that amidst the names that we've been called over the years, over the months, we've been named everything. They've insulted us. We've actually paid the price. Some of us do not serve any committee in the National Assembly because of our stand on the element of changing the law. Today, we have been vindicated. It is even more, enticing that the Constitution of Kenya, that the Kenyans passed in 2010, is able to fight for itself. Everything that you saw the judges read, every pronouncement made by the judges was a self-defending case by the Constitution of Kenya. But there are two issues that we need to ask ourselves. Is it that the Attorney General of this country does not understand his role? Or is it that the president does not listen to the legal advice. I do not want to believe that the legal mindset of an attorney general with a long standing of the legal profession can misadvise the president. But if it indeed happened, as we've seen, then it's about time the Attorney General of the Republic of Kenya resign. Stop taking money, public money, being paid public money to misadvise the president. But if it is indeed true that you advise the president otherwise, and he failed to listen, then it's clear that the president is one who does not take any contrary opinion, just like we've seen. All the people in the political scene that have got divergent views in one way or another have been edged out, be it in parliament. You remember the famous statement, "We shall revisit," and today the revisitor has been revisited by the revisitee. It is so clear that the president does not allow any divergence. The question before court was whether the entire process of BBI was right. Whether it was a popular initiative or it was a parliamentary initiative. I agree with the judges. There is no way you can call this on a popular initiative. There isn't any way when it was even gazetted by the executive. Kenyans gave parliamentarians power to change the law. There are only two options of changing the law, under Article 257 and 258. One of it is the parliamentary system or the popular system. The popular system. We are on record in Parliament saying that this was not a popular initiative. We wanted definition, whether it was parliamentary or popular. They called it popular initiative. There is no law that gives the president power to initiate a process on behalf of Wanjiku. Wanjiku gave the power to parliamentarians. You cannot use public money to initiate a popular initiative. If you want to use public money to change the constitution, you can only use public money through parliamentarians. That is why every constituency has got a representative in parliament to change the law on their behalf. So those two options were not rightly used. And that is why today we are here to defend the judiciary, the brave 5 men and 4 men and 1 lady that came out and defended our constitution. This is victory not only to this country, but to the jurisprudence of this world. That the president of any country cannot sit or wake up one morning and say, today we are changing the law and this is the direction we should go. We are on record of raising the issue of multiple choice questions. That, if I get it right, is enshrined again in our Elections Act of 2016. That instead of wholesomely pushing people to pass a collective omnibus, yes or no, like an omnibus thing, like it's a yes or no, give people options on what they want to change. Do they want a bloated parliament? Do they want an ombudsman? Do they want powers of the National Police Service to be given back to one individual in the name of Inspector General of Police? Do they want some of the commissions to be, lowered in terms of power and be given to one body? Those are the questions that we raised. And we were called madmen. We were called, people who are, the Tangatanga. People who are fighting the executive. I do not understand where this notion of giving a divergent view came out from. That anytime you give a divergent view, you are regarded as an enemy of the state, as a person who does not want things to go right. Now, they also brought the element of the constituencies. We raised that issue. We said the Constitution of Kenya 2010 provided for independent bodies. And there is one such independent body called the IEBC. It is clear, and Kenyans know, that it's on record. The chairman of IEBC came out and said at no given time was he given an opportunity to even air his views on the boundaries, on the boundaries and the constitution, the new constituencies that were being proposed. That the 70 constituencies were drafted somewhere in Harambee House, given haphazardly on how political correctness you are. Some made to punish some political nemesis per se, and that is why it has been used as a political tool. That you go to defend the BBI in a certain region, you tell them that you need to pass this thing. You make it even a bait that you need to pass this thing because we gave you a constituency. Power to give, or rather to do boundaries in this country is enshrined in the law, and it's the mandate of the IEBC. And that is why the five-judge bench declared itself and pronounced itself so clear that the president failed completely the integrity test. He failed to protect the constitution that he swore to defend. I mean, really, you swore to defend the constitution that made you the president. Now you, again, along the way, you want to change the very same constitution. Clearly, he defied Article 31, he defied Article 73, and it's at this time that we say we are not ready for, of course, any Kenyan can push a motion of impeachment against the president now, because clearly, when you don't meet Chapter 6 in terms of integrity and leadership and integrity in Chapter 6, which is part of the clearance structures, even as we wait for the exhaustiveness of this thing, because we believe that they are going to go to the Court of Appeal. And I've heard some people say that, they'll go to the Court of Appeal and seek some stay orders of this whole thing. Reggae must continue. I mean, it's already showing the arrogance and pride that you're seeing in these people. You are forcing some things down the throats of Kenyans, which is very funny. But the integrity test against the president is so clear that he has failed to protect the constitution that he swore to defend. There are only two remedies for him. Number one, he needs to come out clear and put the blame where it belongs. The Attorney General of this Republic of Kenya. That is number one blame. He needs to do that. Number two, he needs to give us a framework on how to refund the public money that has been spent. A lot of billions and billions. And Kenyans, remember, 6 billion was released to the BBI committee in terms of collection of views across the country. Public offers, from public offers, 6 billion. You all remember. The president needs to come out and tell us how we are going to get that money back, for development and other things. Some medics have not been paid, some other sectors have not been paid, and we need that money to pay such sectors. Number three, the president should come out and apologize to Kenyans, with Right Honorable Raila Odinga, and tell them we misled you, we own up the mistake, we are ready now to mend our faces. For the remaining 1.5 years, I'll be a good president. I'll not use a lot of arrogance. I'll be so soft to every person. You become more, conciliatory than being so arrogant and pushy, and fighting some battles. It's so embarrassing to even, by the way, it's very embarrassing to even go to the Court of Appeal, because the 800-page judgment was so exhaustive, was very comprehensive on facts and law. We are so cautious and very keen to observe what facts of law they'll use to go to the Court of Appeal. And I'm sure, perhaps certain, that the elements they'll perhaps want to raise are the factual elements about the integrity of the president and the elements of constitutionalism of the IEBC Commission as it is, as currently constituted. But having said that, let the president show us now that he defends the Constitution. We are a bit scared. We've seen the history of our president. When the Supreme Court ruled against his victory, you saw how the president came out and blessing and calling them, and saying he'll revisit. We've seen the court pronounce itself on 41 judges. Now there are 40 because one passed on. Can you imagine, one passed on even before, being sworn in, and perhaps it's out of pressure. Now, the 40 judges, the court directed the president to swear in 40 judges. He declined. The court directed the executive to have Miguna back. They declined. The court directed the president on so many things, including the demolitions that we've seen in this country, all over. But the president has failed to honor that. But here the president wants to make a constitution that he knows very well that the executive under him will not honor that very same laws. It's about time now the president comes out and defends this constitution. We wish him well. We are not celebrating the ruling was against the president. We are actually celebrating that we won the Kenyan public won against manipulation and dictatorship that you are seeing. Because it was a very wrong precedence that once Uhuru Kenyatta manages to change the law, then it's clear that any other predecessor after him will again come up with the same notion of public participation, of popular initiative and push to change the law to suit their interests. And that is why today we are saying we are very happy. And us as members of parliament who voted no, we are extremely happy. We have been vindicated. This has nothing to do with our presidential candidate. This has